Good morning and welcome to this Friday, March 22nd, 2024, 9:30 a.m. joint committee agenda between the Hawaii State Senate Committees on Commerce and Consumer Protection and the Committee on Housing to consider Senate Concurrent Resolution 115 and Senate Resolution 98, encouraging developers to incorporate net zero water building strategies when constructing and renovating housing projects in the state. This is a live hearing. Our typical protocol in hearings is a 2-minute testimony limit. So if you're new here, please use that time to clarify your written remarks. We have reviewed your written testimony. First up, we have Kristen Young in support. Online?
Not present on Zoom, Chair.
Thank you. We also have testimony, written testimony in support from Dean Minakami from the HHFDC. Support from the Ulupono Initiative, and late testimony and support from Chanel Sabala Bumanlog, Cassandra Chi, Isaiah Smith, Makaiva Kanui, and Stephen Wood. Is there anyone else who would like to testify? Okay, seeing as how we don't have anyone to ask questions of, with the indulgence of the chair, I'm prepared to make a recommendation. Okay, the recommendation is to pass this resolution unamended. Is there any discussion? Okay, seeing none, Vice Chair for the vote on both measures, SCR 115 and SR 98. Again, the recommendation is to pass unamended and the chair votes aye.
Thank you very much. Vice Chair also votes aye. Senator McKelvey is excused. Senator Richards.
Aye.
Senator Awa. Okay, he is also excused. Your recommendation is adopted.
Thank you very much. No, you gotta, Monday is the deadline. Really? Yeah. Oh, no, it's a single, right? It's a single. Yeah, sorry, I was wrong. So we'll just do it.
Okay, we have quorum.
Committee on Housing, same recommendation, to pass unamended. Chair votes aye.
Chair votes aye, Vice Chair votes aye. Senator Kino. Aye. Senator Kano is excused. Senator Awa is excused. Chair recommendation adopted.
Thank you very much.
All right, thank you very much. We're adjourned. Okay, good morning and welcome. This is our Friday, March 22nd, 2024, 9:32 a.m. joint committee agenda between the committees on Commerce and Consumer Protection and the Committee on Judiciary to consider Senate Concurrent Resolution 163 and Senate Resolution 137, requesting the Department of the Attorney General to conduct a study to determine the effectiveness of existing state laws in addressing the false labeling of Hawaii-made food products. First up, we have the Department of Agriculture with comments.
Good morning, Chair, Vice Chairs.
Good morning.
Members of the committee, Sharon Hurd, Department of Agriculture. The department stands on its written testimony, but wanting to point out that there are currently 2 laws in the state governing the Made in Hawaii labeling, and wanted to point out that the committee that does the study needs to address both of them or one of them, but there shouldn't be confusion as to which law that they're studying, or maybe both. And that there was a study conducted by DBET a few years ago. The conclusions were 2. One is that whatever agency governs or administers the Made in Hawaii program, it should be one department. It shouldn't be 2. And that the same department should also handle the enforcement of the program as well as administering. That's it. Thank you for the opportunity.
Thank you very much. Next, we have the Attorney General's office in opposition.
Good morning, Deputy Attorney General Travis Moon. The Department of the Attorney General respectfully opposes SCR 163 and SR 137 and requests that all references to the department be deleted. I'm available for any questions. Thank you.
Thank you very much. We also have written testimony, all in support from the following individuals. Nicole Galais of the Hawaii Cattlemen's Council, Brian Miyamoto of the Hawaii Farm Bureau, and Glenn Kagamita. Is there anyone else who would like to testify? Members, questions?
Chair,
Senator Richards.
Director.
Good morning.
Good morning. Thank you for being here. Opinion of, and I realize we haven't done the work, but you've been working with DOA long enough and working with marketing and all that. I don't see anybody from industry. Opinion of how good are we dealing with enforcing or being truthful to our labeling?
We found it to be truthful locally. The members that they're using the Made in Hawaii with the Aloha label, the logo, they have to go through a test or a formula, and that part is good. What we're lacking on is the enforcement on the mainland, and I know we don't have jurisdiction on the mainland, but recently the Aloha Poke story, where Chicago trademarked that, and then Jimmy Chan had to change the name of his product from Hawaiian Chip Company because somebody on the mainland had trademarked Hawaiian Chip Company. So we are not good with enforcing on the mainland. In fact, the DBET study that attacked that concluded that it was $14.4 million that we're losing because of place-based marketing, that we can't control what's going on the mainland, but we can control what's going on here. We're doing a good job here.
Okay, thank you.
Chair.
For the AG, let's see what you do. So is it, you don't think we need a study at all, or you don't think it's the Attorney General's office that's the best to conduct it, or
Yes, the latter.
why do you not think why do you think the AG is not the best to conduct it?
Well, I think that there's a lot of issues that a lot of matters that go beyond the purview of our office. I think there could be a lot of economic and statistical data gathering that's necessary to conduct a thorough study. I think looking at what the resolution or the study wants to accomplish, it's about the effectiveness of the current law. And I think it might go beyond what's on the paper, what we can read in a case. It might be having to talk to the community, if any private citizens have, done litigation to enforce these truth in labeling violations, like what's their cost, what's their benefit. It might go beyond legal research.
If you had assistance from another department that would take care of that part of it, that's not the strictly legal stuff?
I'm not at liberty to really make that call. I can talk to my supervisor or the Attorney General.
So why did they, okay, okay, that's fine. All right, thanks, Chair.
Vice Chair.
Perhaps if your office has been aware of some of these specific issues, what are, other remedies that the state of Hawaii can pursue on behalf of Hawaii companies to ensure and protect, our place-based trademarking?
Other than what's in the HRS, I'm not too sure.
Okay, so in terms of instances where your agency has looked at this issue, are there other approaches that, the AG's office has reviewed that seem to make sense if perhaps, you don't have the full range of tools available to us here?
So I haven't been involved in any enforcement action regarding truth in labeling or any of that litigation. So I'm not aware of any.
Okay, thank you.
Yeah.
Follow-up, Chair.
Senator Richards.
I think just by the questions from my colleagues, it's a big deal for us. And trying to protect the label, I'm sure you've seen some of the legislation introduced concerning coffee and MacNut and all. I think the questions are well pointed because it's not just identifying it, but then what can we actually do about it? And that's the big thing. And so that's why I hear what you're saying about the financial analysis of impact on industries, but the legal solutions that potentially are in front of us or not, in which case that's what we have to figure out if we can change that. So I think that's where the AG is important on this. And that's more of a comment rather than a question. But I think we need to go back and think about that. And that's why I think the direction for the AG to take lead and having help is not a bad one. Comment.
My discussions with my supervisor and the AG, I mean, it didn't go beyond than what's in my testimony. But I mean, I can go back to them and
I would ask that you
discuss
do
with
that.
them what we talked about today.
Okay, thank
Okay,
you.
thank you.
Chair.
So Chair? I have a
Senator
question.
San Buenaventura.
Okay, thank you. So I understand the AG's reluctance because you folks don't have a stable or at least one AG who is assigned to trademark protection, copyright protection. But I'm thinking like maybe instead of the AG, we ask the University of Hawaii Law School as part of their Hawaii Bar Journal to do a trademark and copyright analysis. I mean, why is it that Kentucky is able to, they're able to trademark bourbon and they're able to stop everyone else from using the word bourbon. And so everyone else uses whiskey when it's basically the same thing, but it's not from Kentucky, right? So why, and I brought this up with CPN chair and back earlier. I mean, why is it like France can copyright and trademark champagne? Everyone else has to use sparkling wine, Maybe we need that kind of analysis. That way we know where the state can spend its money on how to enforce, especially where there is this monetary drain on the economy for people exploiting Hawaii that's not Hawaii-based. So is that a kind of amendment that you would be okay with? I think so, because it's not AG. Having the University of Hawaii conduct a trademark copyright analysis to determine how other jurisdictions are able to enforce place-based products.
I think that's within the legislature's judgment to involve UH or not.
And Director Hurd, you heard my question. Would you be okay with that instead of the Attorney General? Because it doesn't sound like they have the expertise, and that's the reason why they're unwilling to do this.
Senator, I think the problem for the department is not so much the who does the jurisdiction, who does the research, but the
Yeah, it does
companies
get
that have
done.
done that. It's exorbitantly expensive. In order for, Idaho potato, California wine, Kentucky bourbon.
Yeah.
They have people just go out in droves and it's very expensive. So we would be happy to do that. I think, with the proper enforcement team, but oh my goodness, it costs so much money
Okay.
to do that.
Thank you.
Well, and so if I can follow up with perhaps you, I think part of it costs so much to do that the chair may be alluding to, and if I am misinterpreting you, then please feel free to come up and correct me, is in large part the aggressive litigation posture that owners of trademarks need to take in order to protect the integrity of the trademark. And that seems to be a pretty significant part of the problem here. When you take, for example, a product like King's Hawaiian, the sweetbread rolls, they don't have any presence in Hawaii at all. And nobody's taken the steps to sue them. We do have local food companies who are engaged in trademark protection litigation, and it is extremely costly, into the millions of dollars, which is an unrealistic, in many cases, expectation to place on local businesses that are struggling with cost and everything else. So I think that's part of why your office was initially requested in this measure to take the lead on it. What is your sort of offhand response to that?
I don't have an offhand response to that.
Right. So rather than putting the responsibility for this, because much of that is a financial analysis from a legal standpoint in nature. So I think it would be maybe also not well-placed to have the University of Hawaii conducting it. And I would be uncomfortable personally to have the Legislative Reference Bureau do it when so much of it does ultimately, I think, come down to litigation strategy in some sort of coordinated effort between the state, which has an interest, and these individual businesses, whether it's coffee or macadamia or whatever. So, well, you cannot answer anyway. So I think I'm just going to move into, thank you for coming up here and just taking these arrows from us. And then, Chair, with your indulgence, I think maybe we can make recommendations. Sure. Okay, so members, the recommendation on this measure would be to amend the resolution to request that the Attorney General's office lead a working group composed of representatives from the University of Hawaii, the Hawaii Department of Agriculture, the Department of Business, Economic Development, and Tourism, and I'm going to also add the DCCA, Office of Consumer Protection, to conduct said the study with the similar objectives outlined in the resolution, but also a specific emphasis on the legal mechanisms and costs associated with protecting Hawaii brands. Any discussion? Vice Chair?
Would you envision the Attorney General's office also soliciting assistance from the Bar Association's individual sections? Because I believe there is a section.
Intellectual property section?
Intellectual property, right.
Yes, I think I would envision that.
Okay, thank you.
You might, Chair, you mind if we also just add a provision that allows that the group that you've named to add other people if they deem it necessary? I'm not sure we've thought of everybody right now.
Certainly.
Okay.
Any other discussion?
Chair.
Senator Richards?
Yeah, assigning another working group, I always get leery on, but in this situation, I think it's warranted because you're going to have to put together, and this is a big deal if we're going to take agriculture forward. So thank you, Chair.
Okay, thank you very much. If there are no other comments or questions, then the recommendation is to pass the resolution with amendments. Chair votes aye.
Thank you. Vice Chair also votes aye. Senator Richards?
Aye.
Senators McKelvey and Awa are excused. Your recommendation is adopted.
Thank you.
For JDC members, same recommendation. Questions or concerns? If not, Senator Gabbard for vote.
Okay, for JDC, Chair Rhodes?
Aye.
Vice Chair votes aye. Senator Elefante?
Aye.
Senator San Buenaventura?
Aye.
Senator Awa? Excused? Measure passes.
Thank you very much. We're adjourned. Okay, good morning and welcome. We're convening this Friday, March 22nd, 2024, 9:36 a.m. agenda in conference room 229. It's a joint agenda between the Hawaii State Senate Committee on Commerce and Consumer Protection and the Committee on Public Safety and Intergovernmental and Military Affairs to consider three Senate concurrent resolutions and their counterpart Senate resolutions. The first is SCR 182 and SR 156, urging the Public Utilities Commission to honor and comply with its statutory duty to investigate the causes of the August 2023 Maui wildfires as required by Section 269-9 Hawaii Revised Statutes. First up, Department of Commerce and Consumer Affairs, Division of Consumer Advocacy with comments.
Good morning, Chair, Vice Chairs, members of the committee. My name is Mike Langelo. I'm the Executive Director of the Division of Consumer Advocacy, the Department of Commerce and Consumer Affairs. We stand by our written testimony, providing comments and available for any questions. Thank you.
Thank you very much. PUC with comments.
Aloha, good morning. Chair Akio Kolole, Chair Wakai, Vice Chairs Fukunaga, Elefante, and members of the committees. My name is Colin Yost. I'm one of the three commissioners at the Hawaii Public Utilities Commission. And I'm here before you because I'd like to briefly add to the PUC's submitted written testimony with your permission. The critical issues in the resolutions are actually my motivation to continue serving on the Public Utilities Commission as a commission. As we all know, this is a precarious time for our communities, our utilities, and our state. It's entirely appropriate for the Senate in its oversight role to ask hard questions of state agencies and to insist on the highest level of performance. We must persevere in our efforts to rebuild the Lahaina community and prevent future tragedies like the devastation of Lahaina. Now, due to the PUC's quasi-judicial nature and the often technical work that we do, the full extent of the PUC's activities can be hard to track. We hope that the provision of written testimony on the subject resolutions will be helpful to the Senate. And as our written remarks make clear, we fully support and will continue to implement the intent of these resolutions to effectively investigate utility-related accidents and to insist that utilities provide reliable and affordable services to the public. Mahalo for the opportunity, and I'm available for questions.
You'll certainly get them. Thank you. Next, we have Life of the Land and Sport. Good morning.
Good morning. Aloha. Henry Curtis, Executive Director of Life of the Land. Like most sections of state law, there is nothing in 269-9 that specifies that it can be delayed or put off. The section of the law clearly states that the Public Utilities Commission must open a proceeding to investigate the fire. The benefit is not only what happened, but how to prevent it in the future. The Public Utilities Commission is addressing the issue in multiple dockets and non-dockets scattered around their website. It would be convenient for the public to have one source, one site to refer to. It's been 7 months since the fire occurred, and we need answers, and the Public Utilities Commission is the place to open a proceeding. Mahalo.
Thank you very much. Is there anyone else who would like to testify on this measure? Okay, members, questions? Okay, PUC, I'll ask first. Why did we need to hold this resolution to have an update from the PUC on what you guys are doing?
Chair, I'm not sure why. I've offered to provide information at anyone's asking, and that's been my approach to it. In terms of the commission, we did provide information, obviously, to Congress on these matters. We explained what we were doing, but I think, given what Henry just said, the real issue here is the question about why didn't the PUC open a public investigative docket already? Why haven't we done that yet? And the reasons are twofold. First, PUC has lots of different investigatory methods, not just dockets. We did launch an investigation into these matters immediately following the incident, but we did not launch an official docket for 2 reasons, and we still have an open one for 2 reasons. First one is that if you look at 269-9, it talks about causation. We are not forensic fire investigators. We do not have the competency or the resources to figure out exactly the cause of the Lahaina fires and determine, who's responsible, et cetera. The ATF, Maui Fire Department, are on point on that issue,
So,
and we've been
Commissioner
supporting
Yost,
them.
if I can,
Yeah,
if I
of
can
course.
just interject right there.
Of course.
The County of Maui is implicated in I think every lawsuit that's been filed by attorneys on behalf of fire victims. Don't you see a conflict of interest presented by the fact that Maui County is responsible for the causation investigation? And isn't it your role pursuant to 269-9 to intercede, to ensure that any potential conflict of interest is cured in the interest of the public?
I think I understand your concern. I'm not sure that I can sit here and say whether or not a conflict exists. However, we have the ATF involved as well.
Isn't it your duty under 269-9 to investigate that conflict, to ensure that in the public interest, we are understanding exactly what happened in this situation?
So the second point that I was going to make after the causation issue, if I may, is the other reason we didn't open the docket is that we quickly realized how complicated this incident and disaster is and was. We started conferring with our colleagues in California to understand how they developed their responses and policies and programs to the wildfires there, which were similar in devastation. And it took them years, the regulators in California, to figure out the right answer of how to respond and what changes to utility operations were appropriate. We also learned that what they developed, although it's pretty robust at this point, is not a direct template for Hawaii. Hawaii has a completely different grid infrastructure. It also has microclimates and a lot of other issues that are very different than California. So in order to even understand the right questions to ask, and that's the thing, once you get a docket rolling, like once you open a public docket, you have to know where you're going, right? You have to have a plan of what's your end game. Are you headed in the right direction? Otherwise, they can kind of spin out of control. And this is a complicated situation all of us are in, with hundreds of lawsuits filed and a lot of other stuff swirling around. So we wanted to make sure that what we're doing is effective. We wanted to make sure we got answers quickly to technical issues, to grid operation issues that bear upon the safety of the way the grid is being operated right now, whether to what extent other parts of the state are similarly vulnerable to Lahaina and they need to be protected fast. A docket is kind of a slow, laborious process by its nature. It's got due process, it's got a lot of things related to it. So instead, we launched an investigation less formal than that by asking questions of the utility, by asking questions of other regulators in other states and other authorities on the subject. And we've learned a lot. We're not quite at the point where it makes sense to open a docket. I think, though, that what comes out of the Maui Fire report, which is supposed to be informed by ATF, that's going to be a turning point for us, right? We're going to look at that, and depending on what that says, we may shift course. We may decide to investigate in new ways, as appropriate. But I can't really say exactly what will happen until we see what's in that report. And as you say, if there's a concern about a conflict of interest, I think that would likely be self-evident in whatever the content of that report is. I don't want to presume that a conflict exists before the report itself is issued.
So I appreciate everything you're saying, and I can understand the position that you're taking, and it seems consistent with the written testimony. But another testifier in their written testimony criticized the PUC for in the past, and then perhaps now, taking a passive and reactive posture when it comes to its oversight responsibilities of electrical utilities. And it's hard to argue with that if this is going to be the PUC's position, when it appears like we have perhaps an uncurable conflict of interest between the entity that's charged with determining the cause of the fire and their role potentially in causing the fire. And the PUC is supposed to be the neutral third-party entity to cure those types of conflicts, is it not?
Well, as I said at the beginning, we don't, this is an unprecedented incident. We do not currently have the expertise or the resources to engage in that type of causation investigation. It's extraordinarily complex.
But I'm asking about the conflict, because the absence of a PUC determination on whether there's a conflict or not is a determination.
I don't think we are statutorily, I don't mean to argue with you, but I don't see anything in our statute that requires us to resolve potential conflicts like that. I don't think that's our role. I see what you're saying, and it's a real concern.
Well, but your stated position is you're going to wait until the results of the investigation are published, and those results could be colored upon their publication because of the situation. And so that is a passive and reactive approach. And I think it sets this whole situation up awkwardly.
if we had the resources and expertise to independently investigate the cause of the incident, then I think you would have a good point, right? I think that it would have made sense for us to have a separate investigation, operating in parallel. We don't have those resources. We aren't able to perform that task. So, even if what you're saying, even if we assume that all makes, sense, it's just not something that we're in a position to do. So I don't know how we could, but however, if that report comes out and it's unsatisfactory to us or, to other stakeholders in the state who urge us to take different action because of what's in the report, that's something that we can address more directly. It's a narrower task, and perhaps we could, if we need more resources, we could come back to the state and request them. We're not funded by general funds. We've got a pretty limited budget, just that comes in through the fees that are charged on utility bills. So, we're not a very robust agency, honestly. California, I know it's a much bigger state, but they've got, after the wildfires really became an issue in California, they developed an entirely separate office with 120 people in it that just focus on wildfire safety. And every year they issue a wildfire safety certification to the utilities. And it's a very elaborate process that they go through. And if that certification is granted, then those utilities have access to the $24 billion wildfire mitigation fund. And we don't have any of those things in Hawaii. Do we need something more robust than we have now? Absolutely. And there's been a lot of discussion in the legislature this year about what should we do, what agencies should be responsible, and should there be a state fire marshal, things like that. Those are all important discussions, and I know that the legislature will take significant action this session. I have confidence that it will on those things. If it wants to give us more responsibility and more resources, if that turns out to be the best answer, then we'll take on that responsibility and perform it. But right now, we're not very powerful. We don't have the resources to really engage in that kind of effective counterpoint like you're discussing. What we would do, it would not be persuasive. It wouldn't be authoritative. We don't have that expertise. So if we did, I agree, it would be appropriate to exercise it.
Thank you. Members, questions?
Yeah.
Senator Richards.
I'm going to have to disagree with your statement on that, Commissioner. I think the senator is bringing up a very valid point. We need a third-party clearinghouse, is how I'm seeing it. And though, yes, I appreciate the fact you don't have the expertise, but as you said, I think ATF is part of this. You have experts doing that. And if we have a docket open, as I understand it, then that would be coming to you to evaluate, and then you can make a determination. The senator has been pointing out that, is there a conflict of interest, yes or no, before this gets published? And it should be a proactive, not a reactive response to this. Grant, this is unprecedented, and we are a little bit different, but in my mind, if the PUC is evaluating what's coming in, that's what the docket would allow, and you're the clearinghouse waiting for the experts to weigh in before we have a public statement going forth, because you do regulate, and I would argue that you, in fact, do have the authority to do this, because that's what we're trying to do. And we're trying to get this to make sure that it is precise, it's accurate, because the public wants to know what happened. And so we need that regulatory oversight, which is what you bring to the table. So I respectfully disagree with your perspective on that, because I think the senator's right on this one.
Okay, may I respond briefly?
Please.
In our investigation that's ongoing, we've been focused on, we're not forensic fire investigators, but we do know something about utility operation and the engineering and structure of grids, right? So the questions that we've been asking have focused on the equipment relating to, that was involved in the morning fire, right? HECO has stated publicly that their equipment likely ignited the morning fire in Lahaina. So we've asked questions focused on that. Exactly how did that happen? How long, were those lines energized after they hit the ground? Exactly what happened? What sort of equipment was on that line that could have potentially prevented that ignition, all those kind of questions relating to that. So that those questions that we're asking and learning from, we then seek to apply throughout the grid to understand whether other parts of the grid need to be upgraded, improved sooner rather than later, right? So we are doing that, and we started doing that right away. On whether we should have a docket open right now to receive the expertise of ATF and Maui Fire Department once it is released, that's a good question. I think that's something we can take back to the rest of the commission. I'm just one of 3 commissioners.
Correct.
But whether we should prepare for that and be ready to accept that information in a clearinghouse setting and be able to then figure out what to do next, that's a suggestion I will take back to my colleagues and talk about. So I really appreciate that. The other thing that's a little complicated here, and Senator Keokalole and I have spoken about this in the past, is that it's my understanding that the ATF report is not going to be a separate report, right? It's going to be provided to Maui Fire Department, and we don't know whether Maui Fire Department will decide to release the guidance given to them by ATF in full, or whether it will just release its own report. So, I think that's one of the issues I think the senator is maybe concerned about. We're also going to need to look at that, right? We're going to need to look and see whether, I think all of us are interested in seeing what the ATF said, independent from Maui Fire.
I agree with you on that. And that's why if we had an open docket, then you have that clearinghouse so you can bring this information in. You don't have the expertise on staff, I got it. But you do have the ability, because as you stated, you've already investigating what was energized and all that, and you do have all that expertise and the ability to ask those questions. And that's what I think this resolution is saying. You need to take it one step further and be that clearinghouse so you can review that and make those determinations.
Yeah, I really appreciate that feedback, and I take it to heart, and I'll take it back to my fellow commissioners and discuss that.
Okay, thank you. Thank you, Chair.
Members, Senator Mackay.
Thank you. Mr. Yost, I have some troubles with the rationale as to why you haven't opened up an investigation. I mean, especially the second one, it's complicated. Well, of course it's complicated. That's why we need you to open a docket on this. And we know it's not like California. We know it's different. So even more so, that should be precedent, or what compels you to go investigate it, because it is so different from any other wildfire. So I don't quite understand why the reluctance to open up a docket is based on somehow it's complicated. And to your issue of having lack of expertise, and I understand that you probably would have to hire folks who have that expertise to do it, but did you and the PUC even ask for any money to do an investigation?
I do not believe the PUC requested any additional appropriation, no.
Well, the AG's asked us for money to do their investigation. I mean, this is kind of your wheelhouse. You should have asked us for money, figured out who you need to contact, and then tell us what the price tag is for that investigation. But you did nothing in that area. And this idea that somehow you look at the ledge for all of the wildfire mitigation, vegetation management, all of those are really the responsibility of the PUC. You don't need to have a law to do that. You could have initiated all of that, correct?
So on that last point, I agree. PUC doesn't need a law to require wildfire mitigation plans to be filed, or to pursue reliability standards and so forth. We tried to explain in our written testimony, we are actually moving forward on those things, and regardless of what comes out of the legislature this session relating to the HERA bill or wildfire mitigation plans, we will move forward on both of those things to enact additional measures, no matter what happens at the legislature. They're both important things to do at this point.
So is it my understanding that you mentioned earlier that the trigger for you to open up a docket is going to be after whatever the AG's report finds? Is that kind of the timeline?
Not necessarily. And again, I can't really speak for the other 2 commissioners entirely, but I can say that our options are always open. We're ready to change course at any moment if it's appropriate. And thus far, really, in terms of the complexity, Senator, it's really just, we wanted to make sure we were even asking the right questions. We had no experience in dealing with something of this scale and devastation. Others have dealt with things similar to this. As we've dug into it, we kept getting more questions than answers. That's what's been going on. We've been participating, as our testimony said, in 2 different statewide task forces And in those discussions, I've gone to some of the meetings of the state wildfire mitigation task force, which Haima and others, General Hara was leading that at the beginning, right? And in those discussions, a lot of things were clearly just not as simple as anyone thought, right? Like the issue of a red flag warning somehow being an appropriate trigger to turn off the power. That's clearly not the case. Red flag warnings are issued when the winds exceed 20 miles an hour. That's not a justification in most instances to shut off people's power and create a bunch of havoc in the infrastructure. So a lot of additional sensors need to be put in place, weather sensors, temperature sensors, drought condition analysis. There's a whole bunch of stuff that the utility is working with UH right now and the National Weather Service to try to become more sophisticated. And a lot of new technology will be put in place. But I mean, all of these things that are being worked on are being worked on diligently and with urgency, but the answers have not been immediate, right? Like it's more complicated than it looks from the get-go. And when we initiate things like shutting off power, that's got to be done carefully and with consideration of all the vulnerable members of the community and first responders, et cetera. So I know I wish I had better answers and more satisfactory answers, but I can say that we are proceeding in good faith and diligently and trying to do the best we can.
Yeah, but the answers that you're looking for and need to find need to start somewhere. And the fact that you're still stuck at the starting line is, I think, troublesome to a lot of us. And, all the other reports and investigations that are going on are looking at a multitude of different things. Causation, the response, all kinds of other things. Yours is singularly focused on the utility. And we know that at some point, HECO's somewhat responsible for what happens there. And so the things that you mentioned earlier about what kinds of lines, what safety measures could have been, those are probably not going to be issues that are going to be taken up by those other reports. So even more so, you opening up a docket is very important to us understanding what happened and how to make sure it never happens again. So, I really support this resolution because it seems like without this, you gotta just be sitting on your hands and waiting for someone else to figure things out for you. So appreciate your good work and your willingness to get going, but I think sooner is far better than later. Thank you, Chair.
Members, any other questions? Okay, thank you very much. We'll move to the next set of resolutions, which are Senate Concurrent Resolution 186 and Senate Resolution 160, requesting the Insurance Commissioner to conduct a comprehensive study on wildfire risk and insurance, including market-based approaches. One and only testifier is the Insurance Commissioner. Good morning.
Good morning, Chair, Vice Chair. Testifying on behalf of DCC Insurance Division. We stand on our written comments written testimony offering comments. I'll be glad to answer any questions.
Thank you very much. Is there anyone else who would like to testify on this measure? Okay, members, any questions? Vice Chair.
Mr. Ito, since you have said that you would need additional resources for such a study, do you have any kind of order of magnitude in mind?
Well, it depends on the scope. If we are going to do actual studies, then we would need additional resources. If we are going to be tasked with perhaps looking at modeling and do some modeling on wildfires or disaster catastrophe risks, that would also take additional money, resources to do.
Okay, so is your department in discussion with any of the other agencies as to the extent to which you can rely upon or share data with some of those agencies that have been tasked with some of the data gathering responsibilities?
And we've been in contact with other state agencies. Everybody's looking at different issues. We're trying to be proactive. We're in the process of trying to get another property and casualty contract actuary on board. So we're in the process of contracting for additional resources. On the actuary, in terms of modeling, we actually have a modeling program with NAIC that's coming in end of May to really educate our staff in terms of how to look at hurricane models potentially expand into wildfire. At the recent NAIC meeting, I talked to one modeler that is working on a wildfire model for Hawaii. And so there's many things in play, but if specifically we're going to be tasked with trying to create a model, a detailed model in terms of insurance risk and wildfire risk, then it would take substantial resources to contract with a modeler perhaps to do it. But I just wanted to let you know that there are modelers that are looking at creating a Hawaii-specific wildfire model at the present time.
Okay, thank you.
Members?
Just
Senator Richards.
quick follow-up. I think your point, Hawaii is specific because we're very different. You can't just take something from another state. Is that an accurate statement?
Yeah, I mean, and that's always a concern, and that's why with NAIC, the CIPR, they're coming in to do training for our staff to teach us how to review hurricane models, what to look for. It's always been my concern with respect to making sure the hurricane models have Hawaii-specific data and not are relying on the Gulf states or Atlantic states models. And so that's all part of the process that we're going through right now in terms of really getting more educated on how to review hurricane models as well as the potential wildfire risk models.
Yeah, I think geography plays a role in that. We have Mauna Kea, Mauna Loa. Florida doesn't.
That was one of the first, with the model that I talked to a few days, modeler that I talked to a few days ago, I had asked specifically whether they included on the hurricane model, the recent, I wouldn't say recent because it's been a number of years in terms of some of the hurricane tracks as they were approaching Hawaii and whether they incorporated that specific weather data. And I believe he said he didn't think so, but that they will be looking at that. So,
Okay. Thank you. Thank you, Chair.
Any other questions, members? Okay, for the next set of resolutions, I'll yield to the Vice Chair of PSM.
Thank you, Chair. The next set of resolutions, SCR 80 and SR 27, urging the members of Hawaii's congressional delegation to introduce legislation to expand the National Flood Insurance Program to include lava insurance. On our testifier list for SCR 80, all in support, we have Julia Estagoy Kaho'one, Glenn Kagamita, Michael Honda, and Andy Kagimoto, all in support. Anyone else in person or on Zoom that wishes to testify on SCR 80 and SR 27? Okay, if not, members, no one's to ask questions to.
Okay, so let's recess briefly for decision-making. Okay, back for decision-making on this Friday, March 22nd, 2024, 9:36 a.m. agenda. First set of measures are SCR 182 and SR 156 related to the PUC. The recommendation after conferring with our fellow committee is to pass with amendments. We will add a provision requesting that the PUC open an investigatory docket on the wildfires in line with the testimony of Life of the Land. And we will also include a request, we will also include a provision urging the PUC to request that the County of Maui provide an unredacted version of the ATF's causation report. Members, any discussion? Okay, seeing none, Vice Chair for the vote, passing with amendments, Chair votes aye.
Thank you. For the CPN members present, are there any reservations or objections? Hearing none, your recommendation is adopted. Thank you.
Thank you very much.
Okay, same recommendation for PSM with amendments. Chair Wakai?
I vote yes, Senator Elefante.
Aye.
Senator Fukunaga?
Aye.
Senator Rhodes?
Aye.
Senator Awa is excused. Chair, your recommendation is adopted.
Thank you very much. The next set of resolutions are SCR 186 and SR 160. This is the insurance study. The recommendation is to pass this resolution unamended. Any discussion? Okay, seeing none, Chair votes aye.
Thank you. Of the CPN members present, are there any objections or reservations? Hearing none, your recommendation is adopted.
Thank you.
For PSM, same recommendation to pass unamended.
Noting the absence of Senator Awa, any opposition or reservations to the chair's recommendation? Having seen and heard none, chair, your recommendation is adopted.
Thank you, Chair. And for the last one on SCR 80 and SR 27, we're going to pass with amendments to add earthquakes. Any further discussion? If not, Chair Wakai, your Vice Chair votes aye.
Noting the absence of presence of Senator Awa, any reservations or opposition to the chair's recommendation? Having seen and heard none, chair, your recommendation is adopted.
And for CPN, same recommendation. Chair votes aye.
Thank you. Of the CPN members present, any reservations or objections? Hearing none, your recommendation is adopted.
Thank you very much. We're adjourned. Okay, good morning and welcome to this Friday, March 22nd, 2024, 9:38 a.m. agenda in room 229. This is a joint hearing between the Senate Committees on Commerce and Consumer Protection and the Committee on Health and Human Services to consider three different concurrent resolutions. The first is Senate Concurrent Resolution 26, requesting the auditor to conduct a social and financial assessment of proposed mandatory health insurance coverage for step therapy requirements for stage 2 through stage 5 cancer. First up, we have the American Cancer Society's Cancer Action Network, Cynthia Au in support. Okay, and Amy Jacobs for Debbie's Dream Foundation in support. Online.
Not present on Zoom, Chair.
Okay, thank you. We also have testimony submitting, written testimony submitting, all in support from the following individuals: Kirby Shaw of DCAB, Kendall Boyer of Infusion Access Foundation, Darby Gottlieb of AdvaMed, Marsha Horn for ICANN, Ron Shimabuku of the Alzheimer's Association, Ashira Vantries for AMED Alliance, Cheryl Okuma, Deborah Michiko-Freed, and late testimony from Zach Hardy of the Michael J. Fox Foundation. Since there's no one to ask questions,
Sorry, I'm here. This is SCR. I think you might be on the wrong.
Oh, am I on the wrong one?
26, right?
I'm testifying for one.
So you are right. I read all of the testifiers who submitted testimony on the next resolution.
Right. Because I don't see anything for SCR 26.
I don't believe, do we have testimony for, oh, okay. So the reason I got that confused was there's no submitted testimony in favor of SCR 26.
Yeah, I got confused.
So we will just move on that resolution. We'll move to SCR 159, requesting the auditor to assess the social and financial effects of mandatory health insurance coverage for biomarker testing. Good morning.
Good morning, Chair, Vice Chair, and committee members. Cynthia Au on behalf of the American Cancer Society Cancer Action Network. We stand in strong support of SCR 159. I stand on our written testimony, and I just wanted to say that nearly 60% of all cancer drugs that have been approved in the last 5 years require or recommend biomarker testing before use. And I also wanted to just comment that biomarker testing therapies are not only for cancer therapies, but also open to targeted therapies for lupus, ALS, preeclampsia, arthritis, Alzheimer's, and heart disease. So there is use across various different diseases. Thank you.
Thank you very much. Is there anyone else who would like to testify on this measure? So again, in total, we received testimony from 11 individuals, all in support. Members' questions? Okay, we'll move to the last set of resolutions on this agenda, SCR 207 and SR 183, requesting the auditor to conduct a sunrise analysis on mandating dental and vision insurance coverage. Office of the Auditor with comments, and Kirby Shaw of DCAB in support. Is there anyone else who would like to testify? Okay, since there's no one to ask any questions of, Chair, are you ready for recommendations? Okay, we'll move into decision-making.
We need, I got one. Yeah, I know, but I need vote sheets. I'm waiting for vote sheets. Yes, please.
Okay, while we're doing that, we will defer SCR 26 because there's no testimony. The next resolution, SCR 159. This is regarding biomarker testing. The recommendation is to pass unamended. Any discussion? Okay, seeing none, chair votes aye.
Thank you. Of the CPN members present, are there any reservations or objections? Hearing none, your recommendation is adopted.
Thank you.
For HHS, same recommendation. Senator Shimokura for the vote, chair votes aye.
Senator Vice Chair Kino is excused. Senator Gilfillick.
Aye.
Senator Shimokura is aye. Senator Awa excused. Adopted.
Thank you very much. And the last set of resolutions are SCR 207 and SR 183. The recommendation on this, on these measures are to pass with amendments. We will insert SB 2259 SD2 as the bill referenced so that we have a necessary vehicle compliant with the auditor's testimony. Any discussion? Okay, seeing none, passing with amendments. Chair votes aye.
Thank you. Of the CPN members present, are there any reservations or objections? Hearing none, your recommendation is adopted.
Thank you.
So for HHS, same recommendation passed with amendments. Senator Shimokura for the vote.
Okay, of the three members present, any nays or reservations? Seeing none, measures are adopted.
Thank you very much. We're adjourned. Okay, good morning and welcome to our Friday, March 22nd, 2024, 9:40 a.m. agenda in room 229 to consider CPN referred resolutions. The first is SCR 16, requesting that the Hawaii Property Insurance Association expand coverage to commercial properties. I have no registered testimony on this resolution. Is there anyone who would like to testify? Okay, we will move to the next two measures, SCR 82 and SR 68, requesting the director of the DCCA to convene a working group to study and devise comprehensive strategies to restore accessible insurance options to residents and commercial businesses in lava zones 1 and 2. First up, we have the insurance commissioner with comments. Good morning.
Chair, Vice Chair, Senator Richards, coordinator testifying on behalf of DCC Insurance Division. We stand on our written testimony, offering comments, and glad to answer any questions.
Thank you very much. That's all we have. Is there anyone else who would like to testify? Members, questions for the insurance commissioner? Okay, thank you very much. We'll move on to the next set of resos. SCR 124 and SR 106, requesting the Hawaii Hurricane Relief Fund and the insurance commissioner to assess the impacts of climate change on homeowners insurance. Insurance commissioner with comments.
We stand on our written testimony, offering comments.
Thank you very much. Thank you very much. We also have written testimony and support from Climate Protectors Hawaii. Is there anyone else who would like to testify? Members, questions? Moving on, SCR 183 and SR 157, urging the DCCA and Maui County to investigate and enforce applicable laws against landlords who are ending rental agreements to house FEMA-eligible households through the Direct Lease Program or the Department of Human Services Rental Assistance Program. First up, DCCA Office of Consumer Protection with comments. Good morning.
Good morning, Chair, Vice Chair, and Senator Richards. My name is James Evers. I'm an attorney with the Office of Consumer Protection. We have submitted written testimony. I'd just like to clarify, however, while the resolution seems well-intended, it seeks to impose upon OCP a task of litigating matters of landlord-tenant, and that's beyond our authority. At one point, OCP did have that authority, but the disciplinary board of the Hawaii Supreme Court issued several opinions that OCP has conflicts of interest created by our oversight of the landlord-tenant hotline. We have approximately 10,000 calls a year. So we do try and facilitate those disputes, but we do not litigate those. And if litigation is on the horizon, we really don't even investigate. We would prefer that those matters be handled in the private sector. So we certainly see the need, so it's well-intended, but it's something difficult for OCP to get further involved in light of the conflicts of interest cited by the disciplinary board of the Hawaii Supreme Court. That's all I have. Thank you.
Thank you very much. Next we have Eric Arquero for Kaibigan in Lahaina in support. Is there anyone else who would like to testify? Members, questions? I have a question for OCP. If it's not you, then who has jurisdiction?
Well, I think the Attorney General does, and this is an issue that did come up with respect to some of the displaced wildfire tenants. And we did issue an opinion on that that referred the matter back to the Attorney General for their investigation. They're not in the same predicament that we're in with respect to regularly on a daily basis receiving information from both landlords and tenants. And there's just no way to screen that. So.
Okay. Thank you. Any other questions? Thank you very much. We will move on to SCR 93 and SR 79, requesting the insurance commissioner to coordinate and develop a wildfire insurance compact. Insurance commissioner with comments.
I stand on our written testimony offering comments, but I would like to note that there has been discussion between the Western Zone states in terms of trying to create a risk pooling mechanism to assist states in, the catastrophes that are occurring in the Western states. So we already started part of that discussion.
Okay, thank you. Is there anyone else who would like to testify? And are there any questions for the insurance commissioner? Okay, thank you very much. We will move on to SCR 102, requesting the insurance commissioner to consult with the Department of Taxation regarding the establishment of a wind resistance retrofit tax credit program. Insurance commissioner with comments.
Again, we stand on a written testimony offering comments. I'd like to note with respect to mitigation, we have contacted Alabama as well as South Carolina that has created a mitigation program. And so we're in discussion, but the program that they have is not a tax credit. It's a grant similar to what we had previously in 2006 and 2008. But I'd just like to note that.
Thank you. Is there anyone else who would like to testify? Members, questions? All right, we'll move to the last measure on all of the agendas. SCR 158, requesting the Department of Taxation to conduct a study on disallowing the dividends paid deduction for real estate investment trusts. First up, Department of Taxation.
Aloha, Eva Watson here at the Department of Taxation.
Thank you for standing on your testimony. It looks like we have late testimonies submitted by the Land Use Research Foundation, the Hawaii Realtors, and NAREIT, all with comments. Is there anyone else who would like to testify?
We have one person on Zoom, Chair.
Okay, hello, good morning.
Aloha, Chair, Vice Chair, members. My name is Gladys Maroney on behalf of NAREIT Hawaii. Apologies for submitting late testimony, but we appreciate the accommodation on the video. We support the intent behind the reso and offer suggestions in our testimony to expand the study to a more comprehensive one that delves into the true financial impact to Hawaii's economy if the dividends paid deduction available to REITs is repealed. We stand on our testimony, but I would just like to highlight a couple. The first one would be to compare the loss in GET from hotel REITs to any potential increase in corporate income tax revenue. And the study should also include an analysis of the changes in the way REITs would do business in Hawaii if the DPD is repealed. That means, will they delay or withdraw from any construction projects? Will they reduce their investment? Will they invest elsewhere? And how will all of these behaviors impact jobs, GET revenue, and our overall Hawaii economy? I appreciate the opportunity and I'm available for any questions. Thank you.
Thank you. Is there anyone else who would like to testify? Members, any questions? Okay, let's recess briefly for decision-making. Okay, reconvening for decision-making on our Friday, March 22nd, 2024, 9:40 a.m. agenda. The first measure, SCR 16. There was no submitted testimony on this resol, so we will defer. The next set of resolutions are SCR 82 and SR 68. The recommendation on these measures are to defer, and the reason is yesterday this committee passed out a pretty substantive amended version of House Bill 2056, which convenes a reinsurance working group that covers the substance of these resolutions. So we will defer. The next set of resolutions are SCR 124 and SR 106. And the recommendation is to defer these resolutions for the same reason. They are contained in the Senate draft of HB 2056. The next set of resolutions are SCR 183 and SR 157. The recommendation on these resolutions are to amend, to change the request as noted in the testimony to the Attorney General's office and delete the provisions relating to the Office of Consumer Protection. Any discussion? Seeing none, Vice Chair, passing with amendments, Chair votes aye.
Thank you. Of the CPN members present, any reservations, objections? Hearing none, your recommendation is adopted.
Thank you very much. The next set of measures is SCR 93 and SR 79. The recommendation on this resolution is to pass with amendments. Rather than requesting the insurance commissioner to develop a compact, we will instead request the insurance commissioner to research and convene stakeholder discussions around the concept of a wildfire insurance compact. Any discussion? Okay, seeing none, Chair votes aye.
Thank you. Of the CPN members present, any reservations or objections? Hearing none, your recommendation is adopted.
Thank you very much. The next resolution is SCR 102. The recommendation is to defer, no supporting testimony. And the final measure on this agenda is SCR 158. The recommendation on this resolution is to pass with amendments adopting all of the proposed amendments submitted in the late testimony by NAREIT Hawai'i, with the exception of the second bullet point. So the intention here is to request that a neutral fact-finding and study be conducted on the impact of the dividends paid deduction. Any discussion? Okay, seeing none, passing with amendments, Chair votes aye.
Thank you. Vice Chair also votes aye. Senators McKelvey and Awa are excused. Senator Richards.
Aye.
Thank you. Your recommendation is adopted.
Thank you very much. We're adjourned.